I'm an attorney. I'm located in San Francisco. I've worked with the adult entertainment industry for almost my entire legal career, which is like 30 years. And I've worked with ESPLER specifically over the last maybe 10 years. And I participated in this project by helping with some of the records requests. I'm here to talk about something else, but I'm going to make a little pit stop to talk about the records requests. We've talked about a lot of law enforcement agencies did not respond to our requests. And there's really two reasons for this. One is law enforcement is given a great deal of deference within the Public Records Act. And there are a lot of exceptions for law enforcement. And so one thing is, if they are trying to avoid giving documents, they use these various exceptions, sometimes legally and sometimes just by obfuscating and just kind of using them as an excuse. So in that regard, there really needs to be, we should consider at the legislative level some better guidance to law enforcement as to how these exceptions apply and how they don't, maybe tighten up some of those exceptions. And then the other thing is your ability to hold them accountable means that you have to have the money to bring a lawsuit, and without knowing what your chances are. And it's just, it's difficult. So part of the recommendations, I believe, are to revisit some of those issues, and I fully support that. But what I was assigned to talk about today was California's Electronic Communications Privacy Act, often called Cal-ECPA. In 2015, Governor Jerry Brown signed SB 178, which is the Cal-ECPA Act. The bill was introduced by California State Senators Mark Leno, who many of you know from San Francisco, who is very liberal, and Joel Anderson, who's a Republican from Alpine County. So it was jointly introduced. It was supported by the Electronic Frontier Foundation, ACLU of Northern California, California Newspaper Publishers Association, and a wide array of other civil rights groups and technology companies. 2/3 of the California legislature supported the bill. So the reason I mention this is that the bill really reflects the will of the California citizens. I can't think of another bill that has had more support. So what does Cal-ECPA do? Through your personal experiences and from watching movies and television, you probably know that law enforcement generally requires a warrant before they can enter your home. And that's because our homes are our sanctuaries. They're deeply personal to us. There are exceptions, but they're somewhat limited. So what Cal-ECPA really did was to recognize that our digital information, the information on our phones, the information about how we are tracked in many different ways through technology, is also deeply personal. And so in a nutshell, what Cal-ECPA did was to require a warrant for the law enforcement to access that kind of information. When it was signed into law, the EFF reported it like this: Californians can rest assured that law enforcement can't poke around in their digital records without first obtaining a warrant. And Senator Leno said, for far too long, California's digital privacy laws have been stuck in the dark ages, leaving our personal emails, text messages, photos, and smartphones increasingly vulnerable to warrantless searches. That ends today with the governor's signature on Cal-ECPA, a carefully crafted law that protects personal information for all Californians. The bill also ensures that law enforcement officials have the tools they need to continue to fight crime in the digital age. And then one more quote from the other co-sponsor of the bill, Joel Anderson, the Republican. He said, Senator Leno and I helped bridge the gap between progressives and conservatives to make the privacy of Californians a top priority this year. This bipartisan bill protects California's basic civil liberties as the Fourth Amendment and California Constitution intended. Well, that didn't quite turn out to be true. And this report really demonstrates that law enforcement is in many cases violating the act outright, and in all cases violating the spirit of the act. They are, as some folks already talked about, using pressure to gain access to people's telephones when they know very well that they are required to have a warrant to look at that information. So you can be rest assured that if this is happening with the groups of people that our work is specifically concerned about and focused on, it's happening or going to happen with all Californians. And so everyone, not just people who are interested in the rights of sex workers, need to pay attention to this and take it very seriously. It's scary stuff. So that's all I was going to mention today, but I'll be around for question and answer later if you need me.